Well, good afternoon. First, I would like to thank IBDT for the opportunity. Professor Schwery, Flávio Neto, and all the members of, I won't say table, but this panel, on behalf of Professor Marta, Aloysio, the coordinators of this panel. To put within context, it was already said by, I think, Dr. Philippe Renaud, who mentioned the fact that Professor Alcide said that the questions were more important than the answer. This Bertrand Russell said the same. Philosophy growth with the same questions and same way of being answered in satisfactory way, but it moves us to look for right answers. And we will try here to address these answers, to put within context something that could solve all questions and answers. I will ask place to forth for those who are going to answer this huge challenge. Perhaps the importance that our constitution have in all this, the fact that two companies being related or allow the legislature later and leisure do infra-constitutional, infra-legal, and infra-legal standards rules, the skill of concept of income and tax-paying capability for this purpose. In this case, for treaties that address double taxation and other factors. Perhaps the importance is regarding the due legal procedure need rules that limit the drawing up rules and principles limiting the draw of rules and enforcement. And then it was so here debates regarding those countries that have to follow treaties that did not participated when it was made and neither existed when executed. And now for the IE field, also perhaps we have the issue regarding the due legal process that is very important. Very briefly mention this aspect here. With the tax reform, we will have this seriously enforced the IBS CBS, which is the ICMS account that is done by taxpayers, will be done by a algorithm. And if we place the algorithm, we'll do everything automatically, which would be great.
So then they will follow the values that the algorithm should follow when they enforce the tax law. I heard from Professor Matakin, who works in the Treasury Department in the United States, that all the farms there, taxpayers have to pay IPVA or the vehicle tax with a discount, and then they forget and eventually pay that the same tax in different installments. Same thing applies to real estate tax. And my colleague, who also studied with me in law school, said, "Oh, let's give this back to the taxpayers." His boss said, "No, we just return that to those who claim it." Because, for example, you don't give the change that was not given appropriately to people. So, will the algorithms follow the criteria correctly? And which aspects will be considered, especially when we have the strict payment, when we calculate debit, and so on? And then deliver the credit to the taxpayer, which will also be calculated by the algorithm. So let's see the answers to this. So I'm looking forward to hear all of you, and then I'll pass the floor to Professor Marta. So let's start with Professor Aloysio, the co-moderator. I would like to greet everyone. Given the short time we have to address all the questions, so let's go to the first one. This has to do with panel one. So basically, the question is how an international tax organization can coexist with a sovereign state, especially from the perspective of constitution. To answer it, we pass the floor to Dr. Alessandro. Thank you. I'm honored to be here in this wonderful auditorium. Thank you, Professor Schroeder, Professor Flavio, for the excellent congress. It has been a very intensive day, and I have learned a lot. The the World Tax Organization issue is nothing new. We can say that the major global issue here that is not part of an international organization as a UN agency or an international organization that is intergovernmental leads us to three different ways to answer that. One is top down, and the other one is more bottom up. The top down would be something similar to what we have seen with regard to World Trade Organization. So it's an intergovernmental agency that is independent from the UN. Maybe it would be within its natural scope. And the history of World Trade Organization shows us that maybe this pathway is full of dangers. The position of the organization is not really so good because it will be like a stalemate. The other traditional pathway is one that we have seen, especially about which there is a consensus with UN, which is to have a specialized agency. This will make a lot of sense, especially when it refers to global challenges. I would say that this is an international tax organization that is geared to extra tax issues, for example, environmental taxes. The third possibility is what I call the bottom up solution. So this will be based on all the regional experiences that we have seen, like the CIATA in the Americas or ATA in Africa or LOTA, especially in Europe. So we could create a network or administration networks. I believe that the first pathway would be the master one, but more complicated from the constitutional perspective, because it does require a treaty. And there will be sovereignty related to some other issues. And the bottom up process is very much aligned with the theory of the global international law. So I think that it is very promising. But of course, the topic discussed in the last panel is one that really puts people on different sides. But now, because we have these aspects very consolidated, so I think that when we think about the transparency review procedure, maybe this would be the easiest way. So we have, I think the procedures would be something more difficult to handle. Well, my time is up, so I think that I'll just pass the floor to other ones. Here in Brazil, I think that we fear this type of openness. Now, Julia, of course, we cannot exhaust this topic, but my comment on this question is that at first sight, we should create an international tax organization that can really look like a threat to the sovereignty of states, because taxation is in its core a typical manifestation of sovereignty. But there are some comments to be made with regard to this, which is the concept and a legal nature of a tax sovereignty. As Professor Alessandro said, we should also establish a parallel to other suprastatal agencies like the European Union. In the case of an international tax organization, sovereign states will keep their decision-making power, as if to say whether they want to adhere to this treaty. And so sovereignty would just be adjusted in order to allow a more effective coordination with regard to transnational or cross-border issues. And here we have the concept of a multidimensional sovereignty, internal and external. Internal tax sovereignty will be preserved So states will still have control of their tax rates and local taxes. However, external sovereignty that has to do with the ability of a state to influence international issues will be strengthened because these international issues are hardly addressed as enough by states alone. We can also compare that to the European Union and the principle of subsidiarity. As the EU also only intervenes when the state members cannot handle the issues effectively, so an international tax institution can interfere to solve issues that go beyond the ability of the sovereign states to decide on that isolatedly. So this will complement the sovereignty of states and not replace them. So they will operate in an area where global cooperation is key for tax law. In practice, this organization can work as being a facilitator of the tax agency to ensure that every country, regardless of their size or economic power, can receive a fair share of the taxes from their multinational entities. To many countries, this can also mean an increase in tax collection and more tax stability. In my opinion, the coexistence of an international tax organization with sovereign states from the perspective of constitution depends on how we understand sovereignty according to the rule of globalization. Apart from representing loss of control, this agency can strengthen the ability of the states to handle global challenges at the same time that they will preserve their own constitutional autonomies with regard to internal tax issues. Thank you. Thank you, Julia. Well, time is short, and I think that everyone has a comment on this, but I think that that would not be possible. So let's go to the second question. We have two questions, and let's talk about the first one. And if time allows, we go back to the second question from panel 2. The first question of panel 2 is, when the OECD's guidelines and the Brazilian legislation mention that the PIC is the most appropriate method, there are all possible applications that can be applied to the PIC, like a make adjustment or only quotation. So let's hear the comments here. Good afternoon, everyone. I would like to thank Flavio and Schroeder for the invitation to be here. It's a pleasure to be here. I believe that when we speak about this hierarchy of application of the picking method, it's based on the fact that it will be mandatory whenever there is available information that are also reliable to apply this method. So it's not because of the simple fact that there is a quotation that is made. Pink will just be the answer to that. I would like to start by speaking about this hierarchy when we speak about any kind of transaction. The first criterion is to analyze all the financial information available and either internal or external to see whether this is the method that will allow me to apply the principle of arm's length in a more appropriate way. After this, then the Brazilian legislation will also allow the application of all the methods if you can show that the information you have available is not enough to apply that principle. One of the things that I find interesting about the new model is that you, as a taxpayer, to be able to move away from this hierarchy and argument that provided you have good supporting arguments for that. The guidelines do not establish hierarchy for every type of transaction. They simply mention the fact that in commodities, for example, the PIC method would be the most appropriate one. The Brazilian legislation only establishes just recommends the PIC method for every transaction for royalties and interest rates or commodities or any other kind of operation for which you have available internal information. And there is also the hierarchy applied to commodities. When I apply the PIC method and come to the conclusion that it could be the most appropriate method, so whenever we speak about this method and there is a internal comparable, then you can apply this method compared to a quotation. I think this is important because it is not just, if this is the rate that you use, maybe I have an internal information to which I have agreed with a third party that can be much more reliable to be used than just another quotation or rate. In the case of oil, for example, we can have one type of different oil, and the price quoted is not the one that we practice in Brazil. So when we decide to use the PIC method, we can use an internal comparable or an external comparable item. This is the main thing. When we speak about commodities in particular, I know that many Brazilian companies feel that this is too rigid because this is the method to be used. There are some jurisdictions, for example, in Europe, that when you analyze commodities, they can use the method of profitability. For example, in the analysis of a trading company, these analyses are followed by APAs. And according to the jurisdiction, that is methodology accepted. So, can Brazil apply another methodology of profitability in the case of commodities and not using the PIC method that analyzes price against price? I think that there are different pathways. You can use one netback adjustment, which is a method of comparability in which you show that if the end price with a third party is such, and then you can remove what you have as a COP or an expenditure whenever that is according to the market price, and then you agree on the initial price. Another method basically can be that you may have a full quotation price and then you have to clean it as such, and then you isolate it as if it were quoted in the stock market. And another thing that can be a remuneration of the trading is analyzed compared to the entity on the other side, which is less complex in that operation. So you detach the total price that is being agreed. But what I would like to say is that when you speak about commodity, there is an established hierarchy according to the law. But it doesn't mean that there are other arguments to support that, saying that it cannot be used. I think this is the most important aspect. To wrap up, is that when you speak about commodity, even though there is a market price, maybe even though it exists, this stock exchange doesn't have liquidity. So there are many contracts being quoted and negotiated, but none of them is closed. So even though the stock exchange exists, to what extent it does reflect the players in the industry? So this is what I have to say. Even though there is this established hierarchy according to the law, but there is a major part of this that can be developed by the taxpayer in order to somehow, if they have the facts, to use, not to use this methodology. And this is it. Thank you very much. Just additional question. And the hierarchy that we see of the PIC method in the Brazilian law is different compared to other legislations. I think that I can comment on the case of Venezuela. I'm Venezuelan. And there is a specific hierarchy for methodology that is not aligned with the guidelines because the guidelines do not bring all these particular aspects covered. And in Venezuela, you have to discard the PIC method. And as it's written in the Brazilian legislation, it seems to me that in every situation, you have to discard the method and show to the tax authority why you not use it. And in other jurisdictions, even though it is a preferable method because it's more direct and the one that is closest to the arm's length method. But sometimes the comparison doesn't make sense and the methodology has to be used. So you have to analyze the two ends of the transaction and apply the other preference split, for example.
Thank you. There, so we have a reorganization. Now, the second question of panel 2 for Bruna. Bruna, this question is mine. So don't be that harsh. I'm posing the question. So the value attribution of the mean does not offend the contribution capability. Consider each point on the due interval does not call for adjustment. Is it too excessive? It's short due to the limits we have regarding words. So good afternoon. As we mentioned during the panel, and I think the question is well posed, we have to go back when we think about transfer pricing. What are the grounds for these rules and what are constitutional in our country? Therefore, what influences the taxing, contributing, and taxing income? The assumption, well, it will be grounded on Article 9 from treaties, and I try to set forth a price between the parties comparable and set forth by a non-related party. And there's a fiction. I will have a price established by related parties that would be the one enforceable with an independent party. Arm's length act as this element of setting forth a tax-paying capability, transforming into independent parties as a market transaction, as Professor Schwery mentioned. This fixation bring two important points. I have to see a tax-paying capability to tax and income would be grounded on the principle of our equity and contribution capability. With the 43 is not unconstitutional. I will not tax income, as Paulo mentioned, but because I have fixed, I have to have reliability. Therefore, up to when I have an interval going straight, restricting my answer, starting from the tax legislation, when I get a full interval, I don't have some defects on this full interval and not the true reliability on the whole interval. And what we will have regarding OECD guidelines, normally I could argument the use of the full interval if you don't have any defect regarding reliability or any point in the full interval that would lead to any question. Because even if I search to try to adjust, eliminate all differences, I'm still working on a fiction, so I might not have a tax paying contribution that's effective. So it's in the guidelines I pose to reflect. I see in the mean as a certain practice within setting forth the search for payment capability when I have a defect in reliability and what I'm searching for. If I have defect at the ends, I will not get and affect my price by high and lows. I go to the mean point, recalling the mean point is not mean or not weighted mean. That because I use they might have some criteria. In all values of the day, I get the mean point of the day and not affect this point by high and low. So I think it's more adequate and should be enforced for specific cases where I have defects and reliability is affected. So I might be reaching equivalent payment capacity. So we might have the opposite effect according to a question. I don't want to affect the asset part because I have a defect, lots of points, but I think this is up to when within the fiction reliability is enough to say I'm setting forth a tax paying equivalent capability. So I have defects, mean point, to avoid higher distortion. It's a practical measure to avoid distortion that will lead perhaps not having an equivalent tax-paying capability. Thank you for your remarks, but you see no type of inconstitutionality. If I could adopt one of the points regarding the interval being satisfactory, what will I have to add? Better adjustment. So the question is basically, but the thing is that if I have reliability that all intervals in applied and I can enforce a specific value, I could do it. But if I cannot, in how to enforce that range is reliable, it's like commodities transaction, the quotations by minute in the stock exchange. Could we understand more favorable to the taxpayer? The mean point is not the mean, but the mean point in the middle. It provide, it would simplify, bring a point closer to a contribution capacity within the function that we have to establish the transfer pricing. Good afternoon. I was thinking about these points interesting because also thinking about what Professor Hugo mentioned during the opening of our panel, the issue is how much we can detect the real, actual, concrete fact of tax capability in behalf of being practical. Although there's a space of leeway, perhaps we have tax issues that are in the constitution. So we must recognize Brazil faces this difficulty of dealing with international tax law and issues many times out of the scope of the margin of leeway of legislatures due to decisions made positive or negative depending on the professor analyzing decisions of the taxpayer in the sense of tying the system and exercising this exercise based on the constitution. So we have many of our difficulties and issues. Well, with with no further ado to the questions of the third panel, and then here we will follow the idea of posing a question from the third, fourth, and if possible repeat it. I start with the following question regarding digital economy panel. How domestic taxation in Brazil on crypto asset and digital markets is affected by agreements on taxation to avoid income double taxation? I invite first Ricardo Maito and then Paulo Vitor for their remarks. Thank you, Marta. I congratulate my panel peers and our panel, but I have to congratulate the Congress organization, Schwerlus, Fábio, Rodrigo. This question would take the whole time of the panel, the whole day. So just a snapshot of this question. The debate is compatibility among the new rules. So we asked to increase the international tax law is being rewritten. Such rules are compatible with Brazilian treaties. I will talk about income inclusion rule arising from Pillar 2, and we will have a panel about this tomorrow. As known, in a simplified way, the idea of the income inclusion rule is to allow through domestic act the controller company to enforce in top-up tax if the controlled company or any other from the partnership has not taxed its profit in a minimal level, in this case 15%. The concept is this. Why do I chose to say minimal global taxation? Because it's already concrete material we are experiencing with many, we didn't do in Brazil yet, but many countries have implemented. The question is this compatible with treaties? I will talk about the OECD view and my opinion. So, OECD has a view that the minimum tax, global or top-up tax and any complementary has a similar character with SEPSI extended. OECD sets forth that it has a stand on treaty compatibility. So there's no incompatibility regarding a country to tax its own residents in the enforcement of this SFC and the complementary taxes, because taxes will not limit countries to enforce taxes on its own residents. This is according to OECD. Now, I have a certain difficulty with this view. This because, in fact, first, if we think about the outlook of Brazil, we know they have an courts in Brazil ruling saying that's not compatible. We have as Supreme Court, this is the SEPC. If there's a similarity between both entities, we have the Brazil court saying it's not compatible. So I stress I face difficulties because the option defined by Brazilian treaties, most of them regarding business profit, is taxation on profits happening on the component states of resistance. That's it. Unless there's a permanent establishment and so forth. So, my opinion, it's there's an incompatibility. If the treaty per se does not foresee an exception, I don't think we happen with the system. If my time allow, I will not. A few months, I will talk with a client, a Japanese company, and they said, "Well, we entered Brazil. We bought a company aquí. We regional spread, and we are negotiating the spread because we will reduce our tax in Brazil because the Brazilian law allows this." And the person was saying, "Well, I talked with my boss in Japan, and he's not that enthusiastic with this idea." He says, "If you reduce taxation here in Brazil, it makes no difference regarding the group. I will tax." Complementary tax will be done here in Japan. Japan is one of the countries that have approved this the top-up tax rule. So it's shocking if you think about this outlook, because by the way, Brazil signed an agreement with Japan, 40 countries. Business, profit, each one tax the profits of your company on the resident state, and that's what agreed. So it seems to me I see with difficulty the enforcement of these rules without them representing a violation of treaties. I stress, except that Brazil adopt a different policy. I mentioned this expressly, as it did Ricardo mention in the panel, for SEPC rules for some treaties, like with Mexico and other countries, where there's a clear exception that the treaty is enforceable, but if there's CFC rule, there has a prevalence, something like that. That's it. I want to share now for Paulo so he can add with his remarks. Well, I will try to be brief regarding this because due to time constraints. Well, I normally I agree with you, Ricardo. I just have one exception. Schwery always talks about this. Each treaty is one. Therefore, first, we cannot generalize. I tend to think that's necessary to place a clause like this in the treaty. But I'm not that shocked if I look recent treaties of Brazil with connecting with the change in Brazilian treaties policy. Yes, I think Brazil has a policy for treaties, many times not that consistent, sometimes lacking consistency for the reading by the RRF on these treaties. Seeing within the context, I in some moments very consistent. Therefore, if I get recent treaties of Brazil aligned with OECD, Singapore, UK, Switzerland, and the Emirates, anyhow, Uruguay, Argentina, I see there in that treaty, subjacent to it, all a policy of treaties more aligned with OECD, with the principle of neutrality regarding capital export. So between brackets, I'm not that shocked. But with Japan, yes, I'm truly shocked. This is a point I see in the treaty with Japan and all the treaties of Brazil. The clear definition of Brazil's policy for treaties of that time, which was strongly lined by neutrality of imports, strongly lined by the use of treaties with the function of behavior, attracting investments. It's almost a treaty, as Shwedi mentions, to stimulate these structures. So I see treaties with Japan. It shocks me deeply. And with Singapore, perhaps not that much. Thank you. Now, let's go for the question of a fourth panel, and let's hope we have time to go back to the panel for the second question of the third, and perhaps a second question for the fourth. The first question of the fourth, for agreements avoiding double taxation, would be if the amicable procedure with low countries could be avoidable, the possible solution of JCP within Brazil. Now I pass the floor first to Julia and then afterwards to Alana. Thank you, Marta. Well, I would say this is a question from the panel. We wanted to have heard Eric and Ricardo on the subject, that they stayed after the panel talking a long time on about it, possibly what would be the answer. And I would say I don't have an answer that's straightforward, but perhaps the idea would be renegotiation. It seems this was what it could be done. And following the line of Professor Heleno, there would not be a policy of tax practice. Why not in this case? Okay, thinking about adopting the double taxation agrees the JCP with Article 11. I think this would be the remarks that would solve, but of clear being superficial regarding the analysis of this issue. I don't know if there's this is the conclusion they would reach. I think they're already renegotiating. I think this week we will have new things about it. So, do you want to speak? Yes, Professor, please, you can take the floor. Muito.
Giving the opportunity to answer the question. Well, what you should do then is change the treaty. So you have to renegotiate, add a protocol, but what is the consequence then? That it only is operational as from the publication entering into force a change of the treaty by the protocol. What they try to achieve now, that it is actually interest as from the introduction in 1995. Well, that doesn't fly, and the Dutch courts of first instances have said, well, no, without doubt, it is also income from shares. The map has been published only in 2022. So up to that moment, in any case, it will be income from shares. Whether it's interest, yes or no, it didn't have to deal with that, and said, well, then you are allowed to the 25% taxpayer credit, because that is the interest, of course, of the investor. So that is, I think, the big issue, and we already discussed the background, etc., etc. Well, and what is essential in the discussion is Article 11, whether interest on net equity is assimilated with interest income. And if you look at the Dutch case law, the Supreme Court, then you need an explicit rule that says, well, INE is interest, deemed to be interest, for instance, in Brazilian law in order to fly. Because based on Article 31 of the Vienna Convention, we start with the ordinary meaning of the wording, taking into account object and purpose of the rule. And assimilated is not similar to. That's a different wording with a different context, with a different impact. And there we disagree. And also, if you look at the map itself, it only says, well, INE is taxed. Yeah, but dividends are also taxed if the participation exemption does not apply. Yeah, but you can deduct. Yeah, there's also income from, in Australia, for instance, the mandatory redeemable preferred shares, the income is deductible. So that's also not very specific for interest income only. And yeah, we have a withholding tax, yeah. We also have dividend withholding taxes, by the way. So that is not very convincing, I think, as an explanation why it is interest. And up to now, the Dutch courts of first instances have agreed that in any case, up to 2022, when the map was published in the Netherlands, it is also income from shares, and therefore you are entitled to the 25% taxpayer credit. Does that answer your question?
I hope so. Thank you, Professor.
Thank you for the opportunity.
No, thank you. Bom, e agora, por favor, Alina, o que não foi respondido?
So now, Alina, well, I think that this is my hard mission that I have to say something. So I think that I'm going to speak about the amicable procedure itself, because I devote a long time to this. I have several articles published on this. I have some criticism with regard to the use of its procedure under paragraph 3 of Article 25 of the agreement, because it is treated as an interpretation, as Eric said. Treating this as just an interpretation of the treaty, there are some considerations to be made, because according to our system, the treaty is not only negotiated, but it should also go through all the legal procedures, because usually agreements have to be internalized. So if you want to change an agreement, it has to go through all the legislative procedure, and this is a very important concern. And we did this to another amicable procedure. In the case of Spain of technical services, this is exactly the same. And using Article 25.3 to negotiate or to handle the interpretation of what is a technical service and administrative service under this contract signed with Spain, even though we have an agreement signed with Spain, there was a change on the initial concept. Unless you give a dynamic interpretation that is very extensive, the ideal instrument to change the treaty would be renegotiation. But then we come to politics compared to what is adequate in international treaty, and we're always going to advocate for what is the ideal one. I think that Professor Eric is surprised to see that here it's not really common to use interpretation resources in infralegal instruments, and also dealing with the laws that eventually change our legal system. Unfortunately, many times we can only solve these years later, when the Federal Supreme Court has to decide that that law is not interpretative, but rather an update related to that law. So just a last question to close from panel 3 to Professor Alessandro. With reference to Professor João's talk, the definition of relevant law for the creation of value doesn't promote discretionary issues, and this leads to legal uncertainty. I would say that no, because it seems that this is a principle-based approach. So it is based on a principle, and this is why, legally speaking, and also in policy level, it is based on economy. But I say that this has to do with international public law. There is the notion of general link, like sorry, I could not understand what he said. And in terms of tax and economic policies, the theory of the benefit is under a crisis, but I think that is much more coherent with this conceptual paradigm. So in terms of infrastructure, it is tangible, intangible, legal, material, and all of this is linked to the possibility of taxing, even though we have to see what kind of benefit it's protecting. Of course, there is the concept of source. that can be expanded. So, as was also addressed during the presentation, I think that each country, there is the source of country and the residence country, and there is a game between them. So maybe we should go back to the territory concept. And here in Latin America, there is a history that is very different in that sense. So I just would like to close. Sorry, but he has a very strong accent. Could not really understand what he was saying. So we do not have time for other questions. I just would like to congratulate the planning committee for putting up this event. And now together with Paulo and Ricardo, I would like to say that IBDT is very favorable to the idea of raising questions and not necessarily just be pleased with the answers provided, but rather to discuss and debate and write new articles. So this is why it's a pleasure to be here. And now Professor Rugi would just close the work, this panel. As Professor Marta said, answers would not be final, and this is why the questions will always be there moving us. Once again, I would like to thank everyone for the opportunity to be here and also for being invited to participate in this debate. And now I want to declare that all the works of today are closed. Thank you.